So we are very much honored to have Mr. Deepak Srinivas. He is a partner at Rajeshwari and Associates, which is actually a patent law company. Am I right, sir?
Absolutely, sir.
Okay. So,
Intellectual property.
Mr. Srinivas is a registered Indian patent attorney and holds a graduate degree in electronics and telecommunication, a postgraduate diploma degree in business administration, and master's degree in energy and environment. So, he leads the engineering team and has about like 22 years of experience in the field. He specializes in innovation mining, drafting, filing and prosecuting patent applications across jurisdictions and forums like India, PCT, US, PTO, EPO, etc. And he has spearheaded many patent opposition matters in the area of electronic devices in India. He is a regular speaker in various seminars, conferences, and published a number of articles on various patent related subjects. So, without further ado, sir, I think I leave the floor to you.
Thank you, sir. Thank you. I understand the today's the topic is primarily. Let me go back to the topic, and it's a good topic, I would say.
Mhm.
Prototyping, process design, and development. And this is not simply the technical side, but this is linked to the aspect of business model canvas. So
Yes,
there
sir.
is a concept of science development, and there is a concept of the business development which is happening, and both of them are supposed to merge so that the person who is doing the science development also gets the financial remuneration out of the scientific development. So that's the primary issue. So I would say it is not simply doing a arbitrary science or science which is not having real life industrial application. It is a science which has got a real life industrial application, and the primary target that all of the people who are doing the research in that nature of active doing research in that nature of segment really want to get the monetized benefit out of it. When we talk about monetized benefit, we say that there should be some sort of advantage flowing in the monetary sense, not mere recognition, but there should be some sort of commercial advantages. So let us look at what my understanding of prototyping, process design, and development is. My understanding is that these are intermediate stages of the development. At this point of time, you are not completely having a complete package solution in your hand. Generally, if I want to go and purchase, say, a cup, I go to the shop and I have a off-the-shelf cup. I simply go and pick it up and come back home. Whereas the stage of prototyping is not that. The stage of prototyping is comparatively earlier. So it means that I have gone to the potter or the person who is picking the cups. I sit with him, I tell him my demands, or he understands. After performing certain amount of market survey, he understands the demand. He makes certain types of prototypes of the cup, and he goes and tests it out. And that is the stage in which we are at this point there. So generally, a prototype would stop or should generate what we call as a proof of concept. It would give you a proof of concept saying that yes, whatever I was thinking as a workable solution is actually working to some extent. It is not 100% accurate, but definitely it is not non-working. It is working. It may need some refinement, but that is the end target of prototyping, or that's the stage of end of prototyping. Thereafterward, you will go and get the funds, and once you have got the funds, you have got the customer, then you start developing the final product, do the final nitty-gritties, and develop the product. So when that is the actual stage of it, please think about the intellectual property protection at this point of time. Not when you have developed the complete product, but at the stage of prototyping, when you have got certain amount of proof of concept from the prototypes. At that stage itself, please think about IP protection, because once you have got the IP protection at this point of time, you can actually take advantage of it in the business models and bid appropriately and get suitable funds by saying that my creation or my concept for which there is a proof of its workability. Not only it is workable, but it is also IP protected, which means that nobody else can actually go and copy it without my permission. So therefore, when I'm saying that it can't be copied, as a prospective investor, the person will think, oh, fine, that's good enough. My investment is somewhat safer. Nobody will take the concept and implement it widely. And it should not happen that I'm competing with the larger market where I invested on the research and development activities. Subsequent people did not invest on the research and development activities. So therefore, my product is highly priced. It should not happen that way at all. And that is what is the issue of IP protection which comes into picture. Now, when we think about IP protection, there are various forms of IP protection. I have just showcased, the parachute bottles, coconut oil parachute bottle, and you can see that there are many types of IP which are protected here. On the first, you have the design of the bottle, which is aesthetically looking. Then you have the trademark. The parachute with the R is a trademark. On the next one, we have shown the openable part, openable cap. So it can be completely closed, it can be partially opened, and it can be completely opened. Which means that if you are not wanting to take out the oil, you can completely close it. If you want to take out the oil during the month of June, when the oil is freely flowing, you can just open the part cap and take out. And in the month of December, when the oil has freezed and the oil is not really flowing out of the bottle, you can open the remaining part of the bottle, put your hand or a access device such as a spoon, fork or anything inside the bottle and take out the solidified coconut oil and use it. So that's the advantage of the partial cap within the entire cap. Apart from that, there is also that mini pouch of parachute. You can open it, use it one time, and then throw it off. And there you can see the aesthetic part of it, which you can also have a copyright protection. So when it comes to the product and the IP, there can be multiple forms of IP which can be embedded in a single product. And therefore be aware of seeking protection for all forms of IP whenever you're doing the research and development activity. Now, since the topic here is prototyping and process development, I would not assume that there are too much of trademarks, designs, or copyright coming into picture. In terms of prototyping of product, physical product, the design may come into picture. But in terms of prototyping of pure industrial devices, there may not be too much of designs. Likewise, there may not be much of copyright or trademark. So what is therefore left out is the patent subject matter. Now, if I come and give you a basic understanding of patent, so the first patent in the whole world was granted somewhere in the year 1421 in Florence, Italy, and it was granted to an architect and engineer. And the patent protection was in the form of monopoly for 3 years. So nobody was allowed to implement the barrage, a barge with hoisting gear used for transporting marbles. That particular equipment, nobody was allowed to manufacture and sell. So only Filippo was allowed to sell this nature of device, and therefore he got the exclusive commercial benefits of his invention. It later on spread to other European countries. Now the patents are being granted almost in all countries across the world. And this is one of the examples of the first patent granted in USA, which is in the year 1850s, and it is pertaining to soap powders and things, and you can see as to how they have advertised. And in terms of India, the first patent was granted for a pankha pulling machine. And now, when we talk about the patent, we say that what is the advantage and why the patent should be obtained. Please consider this Sakshi Toyota story. The Sakshi Toyota is actually the founder of the Toyota Motor Company, today's Toyota Motor Company. And Sakshi Toyota was granted a patent on an automatic and a semi-automatic weaving machine. That was way back in 1920s, 25, something like that. 25 was the date of filing, and 28, 29 he was granted the patent. Once he was granted the patent for the automatic and semi-automatic weaving machine, he licensed it to third parties who are in a position to manufacture the automatic and semi-automatic weaving machine. He did not have the capacity to manufacture the weaving machine for himself. So what he did, he allowed people to manufacture, and that product was a huge hit in the Japanese market. So every time the product was sold by the company, the Sakshi Toyoda used to receive certain royalties from the sales part of it, let's say 3% or 5%. And that itself was a huge amount of money over a period of time. And this actually acted as the seed money for the formation of the Toyota Motor Company. So if you can see that not always you can invent anything, but if you are able to commercially utilize it, you can use the funds thereof, obtain from them and put it in the proper place and get furthermore benefits out of it. And that's what Sakshi Toyoda's story is all about. And let me give one more case study of aspirin. Aspirin in itself is a mild acid and was obtained from a plant which is willow powder from Bath. And it is a pain reliever. All of us know aspirin is a pain reliever. In 1829, a salicin compound was discovered out of it, but that particular compound was very tough on the stomach. And in 1853, Gerard, the person, neutralized this particular salicin compound with acetyl chloride. Okay, so it was an acid, so he neutralized it with acetyl chloride and prepared acetyl salicylic acid. That is how the name aspirin came into picture. But unfortunately, there was no desire to market it, and the entire work was abandoned without any patent in itself. Later on, in the year 1899, one of the Bayer AG's employees, Hoffman, actually rediscovered the Gerard's formula. He did not invent it. He went back and he rediscovered it. And Bayer then patented the process of preparation of it thoroughly. And Bayer called it as aspirin. A standing for acetyl chloride, SPIR standing for the plant, and in is a popular medicinal term, so it became as aspirin. And you would be really surprised to see that the first tablet, even after 1899, there was a huge amount of time gap. So in the year 1915 only, the first tablet of aspirin came into picture and sold worldwide, sold for the first time. Aspirin was later on registered as a proper trademark. And during the First World War, Bayer had to give up this entire protection of monopoly vis-a-vis aspirin. And later on, this aspirin was picked up by almost all the generic companies, generic drug manufacturers across the world. And if you are going to look at it, you would be really surprised to note that almost more than 500 patents have been filed for various aspects of aspirins. Not only aspirin, then they talk about aspirin as salt forms, and then what is the polymorphic form of it, whether it will be crystalline, whether it will be amorphous, what nature of formulations it can be put in, how to make aspirin as part of a soluble solution so that it can be given to pediatric patients. So there are huge number of patents which have been filed on aspirin, and my rough estimate has been close to 500. And there are, even today, you will probably come across some patents which are covering certain aspects of aspirin. Nowadays, the technology is more towards nano emulsions, putting the aspirin powder on carriers, which can be easily given to certain kinds of patients and things of that nature. So it is not that the aspirin story has actually ended. It is still continuing for more than a decade or more than 2 decades almost now. Apart from that, there is also one more story, which is story pertaining to Saprakor. The Saprakor was a US company, pharma company, which was involved in innovation, but it did not innovate blockbuster drugs per se. What it used to do is to take the blockbuster drugs of other people and go and look at the blockbuster drug in a more detailed manner. Sometime it used to find out that certain blockbuster drug has some side effects. If you take, for example, any drug, any pharma drug, and take the leaflet, inside the pamphlet there will be big product brochure and the leaflet. If you carefully read it, it will say that please do not consume it under these conditions. If you are having, let's say, a heart attack or you are a heart ailment is there, please do not consume this or consume it only after consultation with the suitable your consultant, your doctor. Likewise, if you are already taking blood thinning agents, if you are on diabetes, or if you are pregnant, or if you have any other ailments, then there could be side effects, or some of them could give some side effects which are not correlated. So whenever the drug was marketed, the marketing company will indicate the side effects. So the Supracor always used to take up these so-called marketed drugs, blockbuster drugs, and used to find out the side effects or the other disadvantages as I talked about. Once in a while, it used to be in a position to remove one or more of the side effects. So when it removed the side effect, it used to get the product patented in its name after removal of the side effect. And some of the examples of the compounds or the medical drugs which have been patented by Cepracor or Prozac, Claritin, Seldane, some of the blockbuster drugs in which the Cepracor was able to remove the side effects and improved it. And after improving it, it used to give the licenses back to the company which actually innovated the blockbuster drug. So if you take the Seldane here, Hext was the original company which innovated the drug Seldane, but Cepracor had certain side effects. Originally, Cepracor was Cepracor removed the side effects and was granted a patent in the year 1993. Immediately after the grant of the patent, Cepracor did not go and market the product, but rather went to Hext itself. It said that I have removed the side effects which were there in your product and I have got a patent for it. So you are free to come and take the licenses from me. And what was the advantage in this condition was that when Hext went and took the licenses, it was able to make the original Seldane as a obsolete product and introduced the advanced version of it as Allegra. Seldane was banned and Allegra was safer, so Seldane was banned out. But when Hext itself introduced the product Allegra, its monopolistic time period was increased. So you can see that almost it gave Hext an extended market life. Otherwise, the term of the patent is quite, like I initially said, that in the first case, it was for 3 years. Now, when he removed the side effect, he got, let's say, additional few more years term. So the market monopoly life was extended. And so it was a win-win situation for both Hext as well as Cepracor. So let us understand what a patent is. Generally, a patent is understood as a tool which prevents others from commercially utilizing your invention. And it is generally granted for research-based industry. Periods of market exclusivity are crucial, especially for research-based industry, so that they can recoup on the R&D expenses, and it encourages the financial investment in the R&D purposes. Apart from that, patents also give you the advantage of promoting the dissemination of the information in the larger public, so that you are not motivated to keep certain information as a trade secret. And why patent? Not only did I talk about the royalty part of it, not only did I talk about the Seldane story, but apart from that, if somebody is misutilizing your patent, that means if somebody is selling your patent or using your patent without your permission, you can actually go to the court and you can seek damages. Some of the values of damages which the courts have awarded are mentioned here. And even in India, the Indian courts have granted damages up to the extent of 35 lakhs till now. Apart from the damages, there are other things, injunctions and other things which are also granted. So when we talk about patent, it is actually not a right to allow you to practice the invention, but it is a right which is conferred on you to exclude others from practicing your invention. It means it is a negative right. And apart from that, it is a fixed term. It is granted for only a period of 20 years. And also it is granted for a particular territory. So if you look at Indian patent, it is enforceable only in India. It can't be enforced anywhere else. If you have a person who is practicing the same invention in, let's say, Pakistan or Nepal or Bangladesh, you cannot go and enforce the Indian patent in that particular country. You have to seek a separate patent protection in that country so as to go and enforce it in that country. So this is the first misconception. As I said, patent gives the right of use, but no, it gives you the right of excluding others. Now, what is the nature of exclusion which can happen? So assume that I am the inventor and I patented this particular wheel. So what can I exclude? I can not only exclude people from manufacturing the wheel, but additionally, I can exclude people from buying this wheel from unauthorized people and using it in their car. So if I am the manufacturer or I am the patent holder of this particular wheel for the first time, and if let's say my colleague, a big or my one of the big car manufacturers is not buying this product from me, but buying this product from my competitor, then I can actually go and ask him to stop infringing it because his action is also in violation of my patent rights. So that's the advantage. Now, if you look at, are patents granted randomly? No, the patents are not granted randomly. So not for everybody. It's not like an open door where everybody can go inside and sit in a room or in a conference. Patents are granted after rigorous tests only. And these are the criteria for getting a patent granted. The first and foremost criteria is that it should be new or it should be novel, at least till the date of filing of the application. Nobody should have disclosed the invention as such in a single document. Apart from that, it should also have an inventive step. Although it has not been disclosed in a single document as such, but it's variant. It's a marginal variation of something which has been disclosed. Generally, we use the word 19-20 का फर्क in Hindi. So ये 19-20 का फर्क जो है, ये आपको समझाता है कि this is not very high tech innovation. You have not done too much of innovation on it. I'm not talking about jugaads. Please understand, jugaads can also be invention. But I'm talking about 19-20 का फर्क. It's not identical. There are some differences, but those differences are insignificant. Sometimes you can call you can talk about the differences, and the quantum of differences is not material. What is material is what is the impact of the differences. क्या वो 19-20 से बहुत ज्यादा जमीन आसमान का फर्क पड़ता है? So what is the impact of it has to be understood. If the impact is not very huge, then it will be treated as 19-20 ka farak only. But if that 19-20 ka farak gives you a very huge advantage, then it may not be termed as a 19-20 ka farak. So it is not quantitatively how much difference it is. It is actually qualitatively what is the impact of the difference. And thirdly, it should be useful in a particular industry. Most of the time, when we are looking at inventions that you are dealing with, it will be satisfying the third criteria mostly. So I'm not going to too much about it. Apart from that, it should not be excluded as per the local laws. Each jurisdiction has a unique set of laws. We say that this may be an invention, but still I am not going to grant a patent for it. In my country, for example, in India, if you have done an innovation in relation to atomic energy, if you have come up with a very nice brick which is able to stop the radiation, sorry, the Indian government is very clearly saying that no, I'm sorry, I will not give you patent for that. Likewise, if you have done a nice research on how to treat a human being, not the drug per se, but the method of treating, or if you have discovered a new way to remove the cataract, a surgical way to remove the cataract. The government of India is saying that, sorry, it is a good invention, but I'm not going to give you patent for it because of various other commercial and policy driven issues. Okay. So that will keep on changing from country to country. As far as the novelty is concerned, it's a very simple objective test. It is not two, there can be no two answers to novelty. There is always an objective way that is it identical, yes or no. So the question is very simple. There is no subjectivity to this particular test. And if you are not passing this particular objective test, it is not worth taking the case forward at all. Whenever you are passing this objective test that yes, there is a difference, then comes the issue of whether the difference is significant or not. Many times, this particular test is subjective in nature, and there are legal ways to answer to the particular test. You as a scientist, you as a researcher may not know the legal way to answer it. So whenever you find that at least there is a difference, and you are saying that faced with this question of whether it is inventive or not, do not take an answer as no, always seek an expert opinion. Many times people will give you opinion free of cost. They are not going to charge you extensively out of it, they will give you free of cost. So there are specific tests how to adjudicate it. Even after the test, you can still sit down and make the present the data in such a way that on any given day you will qualify the inventive step. I'll give you a very simple example of it. Let us consider that previously there was a three-legged stool, right? And that was the prior art. So I had three legs in the form of an equilateral triangle, and on top of it I put a base, right? It was a three-legged stool. Now I arrive at a four-legged stool and I place the four legs in an equidistant manner from each other in the form of a square or in the form of a rectangle. And I file an application. Many of you will feel that, oh, what's the big deal about it? What's so innovative about it? But if I make you present the data in such a way that I made 100 people sit on the three-legged chair, 10 of them fell, and one of them broke his back. On the other hand, I made all the same 100 people sit on the chair, on the four-legged chair, none of them fell, and therefore none of them broke his back. Now it is the data which is bringing the difference. It's not the difference per se, but it's the impact of the difference which I'm highlighting. I'm not talking about what is the difference. I'm talking about the impact of it. Impact is 10 people did not fall, one of them did not break his back. So that is the impact. So I can present this impact-oriented data, and I can always talk about inventive step. And many times the data is what is important to talk about inventive step, and data only establishes the inventive step. If if the data is properly presented, inventive step will be really very difficult to challenge at any point of time. Now comes the second question, that can I get a patent for a mere idea? No, the patent can't be obtained for mere idea. And that's why when I looked at the initial stage, I talked about the prototype or the proof of concept. So it has to be tied with a proof of concept issue. There has to be a certain amount of clear-cut understanding that the product or the process is workable. Now, when we look at the claims of an application, generally there are, product claims. It covers specifically products per se. Then there can be processes or methods. The method can be, for example, method of making the product, method of purifying the product, things of that nature, method of converting X product into Y product. So those are method claims. And apart from that, there can be use. So I can say that I neither invented the pen nor invented the process of making the pen, but I invented using the pen for the purpose of stirring coffee. So before that day, nobody used the pen for stirring purposes. I did not invent the pen per se, neither I invented the process of making the pen. So this is a very restricted category, use of pen for the stirring purposes. So that can be very restrictive. Many jurisdictions do not allow. Predominantly, it is the product and the method which is being allowed globally. As I said, is everything under the sun patentable? No. In India, there are many other exclusions. Things which are contrary to law, morality, or injurious to public health. These are not patentable. Scientific principle, abstract theories. How to calculate, the value of pi. So it's abstract theory. What is the way to calculate? What is the mechanism to calculate the value of pi? So these are scientific theories, abstract theories, scientific principles. These can't be patented. And there are huge number of other exclusions. Now coming to the stages of the patent. Initially, you have to do the search and all. After that, you file an application. Once you file an application, you have to file a request for examination. Only then the patent office, which is a government body, will take up your application and examine it. Once they examine it, and before that or simultaneously along with that, the application will be published and people from the general public will have the opportunity to oppose your application. They will issue the examination report and you will have to respond to that in an official written communication form. This will go on. In case you are able to meet with all the objections which are communicated in the written form, the application will proceed to grant. You will receive a certificate. After that, there can be once again a challenge to the grant. And thereafter, yearly, you have to pay the renewal fee to the Government of India. In India, the term of the patent is 20 years from the date of filing of the application, subject to you renewing the application on a yearly manner. Apart from that, you also have to keep on informing the Government of India that whether your invention has been actually taken up and marketed, has it been commercialized, has somebody taken a license, have you prepared a product, are you selling the product? You have to keep on informing the patent office about it. That's all. There's nothing wrong in saying that there is nobody till date who has taken it up. There's nothing wrong in stating it, but you should not state something which is incorrect. That's all. Now, if you look at the general path of the R&D, this is what I could see most of the diagrams on the internet which talk about how to innovate. They will say, have a problem, immediately sit and do a brainstorm. Right? So somebody will define a problem, immediately thereafter you sit and do the brainstorm. Once you do the brainstorm, you identified certain probable ideas. But that is an ad hoc basis discussion. You have no understanding of what the prior art is. You have no understanding whether somebody has solved the problem already or not. So my issue would be that do not follow this. Once an objective technical problem has been set, the first and foremost thing is do a search. Only after doing the search, ask the team members to do the search. Only after doing the search, after understanding as to how other people have gone about either addressing the same problem or a similar problem, then only you should actually come down to the table and start doing the brainstorming, not before that. So it is very important to do the search, and the search should be done. In today's time, I would say the search should be done including the patent databases or including the literature which are primarily patent-based literatures, not simply IEEE magazines or your other conference literatures. You must take into consideration patent document, primarily because of the reason that today the concept of doing R&D and filing and publishing the research output without filing a patent application is diminishing. Many people, while they do R&D, they at the end of the R&D, when they have done the prototype and there is a concept proof, they will ask themselves that why don't I file an application out of it? So therefore, the patent application would be available for you to access, and many of them may not be actually published in renowned journals at all. Small innovations or people who have not been able to send that copy of the, the copy of the article to renowned journals, they don't get published. Sometimes you are able to access it on other websites such as LinkedIn or something, but it is extremely difficult. The patent databases, on the other hand, give you a consolidated way to access patent information in multiple languages. You can get documents in Chinese, Japanese, Korean, German, French, all of them in one portal, which is Google Patents itself. You don't have to do any translation. They are all automatically translated, and it will give you all the documents which have been applied for. So the recommended path for the R&D purposes would be to search before actually doing the research. And this will ensure that you are avoiding the basic research. It will tell you, it will give you the technical insight about your predecessors' technical mistakes. So somebody could have solved the problem, but could have faced a particular issue. Apart from that, it will also tell you the trends in the technology, how the industry is prospering, how the industry is going about certain particular areas. It will also be able to identify key players in the field. So if you are developing a particular solution and you do not know to whom you have to go and bid, present, let's say I am making a fan and I do not know to whom I should go and sell the fan, right? I do not know to whom I should go and sell the fan, especially I'm not talking about in India. Let's say I do not know to whom I should go and sell the fan in China. The search here will tell me as to who will be the appropriate person or who will be the appropriate company who will be more than happy to take it up. So it will give me a good amount of insight about it. The search can be done on various databases. These are some of the free databases I have listed on the extreme left. And the paid databases are on the extreme right side, Dialog, Inpadog, and these are Questel, Orbit. These are all paid databases. But at least the left side, USPTO, JPO, EPO, and apart from that, Google Patent are all free databases which you can access online for free. And apart from that, as I said, whenever you are, the patent system is more like a country-specific system. So in case you want protection outside India, then you have to go and file the application in the respective countries of your choice. So, for example, if you feel that the patent has good commercial value or the technology has good commercial value, good prospective in USA, then you can go and file the application in USA. On the other hand, if, for example, if you take malarial drug, there may not be too much of malarial drug. The market for malarial drug may not be USA. The market for malarial drug could be Indonesia, Vietnam. So you can, instead of filing the application in USA, you can file the application in these countries, Brazil, Argentina. These could be the countries where there could be a real market value for the malarial drugs, right? And one of the important things that you must remember is in copyright, the registration is not mandatory. So you can just simply write at the bottom of the article, copyright within C within a circle and put your name and date of creation. But in terms of patent, registration is a must. So you should not publish your invention prior to the date of filing. If you publish your invention even one day before the date of filing, your own document can be cited against you and you can be told that why should I give you monopolistic right? Because the information has come into public domain. So the government has every right to refuse. Only under very rare circumstances, there are some exceptions to that. But please do not go by the exemptions, go by the simple thumb rule that do not publish your invention prior to filing. Apart from that, you can also do one thing. You can file the application, subsequently you can publish. So you can not only profit from that, you can also prosper from various other things. Patent application itself will get published. Apart from that, if you want immediate other recognitions in the form of journals, file the application, then send it to the journals for publication, not before. And I feel that's the part that I have right away. And it's almost 40 minutes. I had, 45 minutes. I've eaten up 42 minutes of it. So I'll now open up the forum for anybody to ask any questions, and I'll be happy to take it up, sir.
Thank you, sir, for such an enlightening talk. So I think we'll have some questions from students. So Harshit, what is your question? Let me see. Okay. Okay. So Harshit question is, I'm just reading the question verbatim. You talked about how a new improved method to surgically improve cataract.
I can read it, sir.
Yeah.
give me one.
Thanks.
Will not be granted a patent. Isn't it somewhat repulsive for researchers and engineers to improve the existing techniques in medical and in other fields as well? How do you define a scheme of to attract researchers and engineers to improve pre-existing techniques if they can't actually cash out heavily from it? See, there are certain things which the government has felt that it should be kept non-protected from IP, and it is the government's decision. And the government only in India has taken that decision. In other jurisdictions, we are not saying that the surgical method for improving or removing cataract cannot be protected globally. In India, it can't be protected. So if you are able to say that that's a very nice cataract removal surgical method, I would rather recommend that you go to some company which is based in USA, license the technology and take the benefit out of it in that particular jurisdiction. But we have no role in commenting upon the government's decision. I would rather say I'm a lawyer, but I'm not a legislator. I'm not the MLA sitting in the parliament and making this decision.
So may I comment something, sir, here?
Sure, please.
Yeah. So Harshit, basically there are certain things that are, say, public interest. I would say that in quotes, there are certain things that are in public interest. So, maybe, you invent a technique for cataract and down the line you become so monopolistic that common people cannot use it. You keep a price of, let's say, 5 lakh rupees for a simple cataract surgery. So, the common people will suffer. So I think that was the, what should I say, rationale of the, people who made that law. Am I right, sir?
So public interest is there as one part of it, but I can't understand the logic behind it too heavily, because I feel that when the drugs are patented.
Yes, sir. Yeah.
Right, when the drugs are patented, so when the drugs are being sold at the same price of 2 lakh rupees per month treatment. So I feel that there has to be a balancing act. Public interest is very important, but there is no clear-cut understanding from anybody as to why only the method of treating human beings and animals was kept as an excluded subject matter in the Indian patent law.
Okay.
I mean, after all, patents are being granted as a monopolistic right. You can balance it always. You can always keep checks and balances to see it that it is not misutilized.
Yeah.
But whatever it was, they have kept it. And as I said, I'm a lawyer. I'm not the legislator to talk about it. It's done, and as of now, it continues.
Sir, I have one more question. So now, last I knew there was a clause that, if you want to file a foreign patent, you have to file an Indian patent first, wait for 6 weeks, and then file a foreign patent.
Absolutely,
so is it still?
Yes, it still exists.
Okay. But what if something is not patentable in India? For that, you can just bypass, right? Like
No,
if
you can't take the decision on your own.
Oh, okay. So you have to file an application as it is. You have to file an application still.
No, the application need not be as it is.
Okay.
But you still have to file an application saying that I wish to go and file, let's say, a method of treating cataract which is not patented in India. Right?
Okay.
Let me take up the same case that you developed a method of treating cataract. It is not patentable in India. you still have to inform to the government of India that I'm going to go and file in other foreign countries this particular method of treating cataract. They will give you the permission.
Okay.
So either you have to file an application, or you have to file a patent application, or you have to file a request, separate request, seeking permission to file abroad.
Oh, okay. Okay.
By the way,
And-
both of them cost same.
Okay. So how much ballpark are we looking at? One thing maybe you did not mention is the cost involved. Okay. So, we are in universities, and often, the university files. And when I was in IIT used to file. So what is the cost involved in, if I want to file, independently, suppose? Is it
The first-
same across the board, or it is different for different categories, and there's something
The
like
first
that?
and foremost, nowadays, my recommendation is, as professors, you have to first and foremost see your contract before saying that I'm eligible to file,
Okay. Okay.
because you may be actually contractually debarred from filing it in your name.
Okay. Okay.
Okay, so that's primary issue. And if you do that, it will be a violation of the contract of employment.
Okay. Okay.
And as far as the costing is concerned, as of today, there is no difference between the fee payable by the individuals and the fee payable by universities.
Hmm. Hmm.
So the fee payable by universities is as low as fee payable by individuals. Previously, there was a difference between the fee payable by individuals and the fee payable by university. It was almost 4 times or 5 times, but nowadays it is at par. The minimum cost is 4,100 rupees is the official fee.
Okay.
Minimum official fee is 4,100. You can't be granted a patent at a value less than that.
Okay. Okay. And then there are associated costs for the lawyers, people who file, and all those costs are there, right?
Sir,
This is the-
obviously, if you wish to engage Ram Jethmalani or Harish Talveji, you can pay. It's as simple as that.
Okay. So one more thing,
What is the system fee is 4,100.
Mhm.
And then comes the professional fee. The professional, depending upon their expertise, obviously they will charge you differently.
Now, sir, there are certain things I believe you said, mathematical formulae, they cannot be patented in India. But is it like computer software? Can they be patented?
So there is a
What is-
restriction called computer software per se.
Okay.
And it's a very dicey domain. I would say that in today's technology, if I'm talking about establishing a communication between you and me via this audio conferencing facility, you know that there is not much of hardware involved in that.
Yeah.
The hardware are standardized. What is
Yeah.
involved is only the software.
Yeah.
But these softwares are giving you a real life effect, putting a technology, bringing a technology to your doorstep and making it available to you. On the other hand, if I'm going to create a software which is going to calculate or predict what could be my mental agony at some point of time, or it can calculate how 2 plus 2 will become, what will be, I give you a general logic which can be implemented as a adder, as a software for addition of 2 elements. So those are not having real life effect. On the other hand, technology driven issues can be said to be having real life effect. So there is a demarcation. The law says something which is devoid of the technical advantage are not patented. Something which is having the technical advancement, technical advantage has a real life effect. Although it is implemented by software, it is still not considered as a computer program per se, and many patents are granted. If you look at the number of filers in India, the top 10, among the top 10 filers, the top 8 filers file applications pertaining to software only.
Okay.
Right?
Okay.
So there is
Yeah.
no issue that, this is to be played properly with. If you badly present it, you can lose out of it. If you present it nicely, you will gain out of it.
So it all boils down to how you present your work, that is.
And obviously, when I go
Yeah.
and make I still remember making my MTech project and standing in front of the guide and talking about if I had gone and did a very bad job of making the PPTs not properly, I mean, I would have got very less mark. So
Hmm.
after all, everything, my marks depend on my presentation skills. So do not ignore the presentation skills.
Yeah.
Even today, whenever we go and write an exam, we say that अच्छा लिखना, खूबसूरत लिखना, मोटे-मोटे अक्षरों में लिखना, सही लिखना नहीं बोलते. पहले तो सही लिखना नहीं बोलते. पहले तो बोलते हैं, let it be,
Legible.
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 Legible. So that's the primary criteria. The presentation is paramount in all fields, not only in patent, for all fields. So please don't misunderstand me on that. But that's what the eligibility and presentation skills are never at par. And that's why we say that since the lawyers or the people who are going to interact with you are going to enhance yours, we are not the inventor. You are the inventor. I can't present your invention in a better way as compared to you at all. Never. But only my presentation skills are far better than you. My scientific skills are never at par with you. My presentation skills are. So you come to me not for my scientific skills, but come to me for a package of my presentation skills plus my scientific skills.
And the law and the knowledge of law.
So the presentation skills are tuned as per the requirement of law.
Okay. So do we have any more questions? If not, let me just present. I thank you, sir. So I'll present the vote of thanks. So thank you, Mr. Deepak Srinivas, for sharing an inspirational and encouraging word on such an important topic. So I sincerely extend my vote of thanks on behalf of the Institute Innovation Council at Amity University, Gurgaon. So I would like to express my gratitude to our honorable founder president, Dr. Ashok Chauhan, for his visionary mission on education, our honorable chancellor, Dr. Asim Chauhan, for his vision on innovation, honorable vice chancellor, Professor P.V. Sharma, pro vice chancellor, Professor Padmakali Banerjee, deputy pro vice chancellor, Professor Vikas Madhukar, who is heading the IIC at AUH, and all the other esteemed dignitaries, head of institutes and faculty members. I thank the students for their presence and listening to Mr. Srinivas. And last but not the least, I must thank the IT team for organizing such support. Thank you so much, sir, for your time. We are extremely
Thank you, sir, for giving me the opportunity of coming in front of at least 40-50 students and staff.
Actually, people were having their external Viva today. So it is exam time. I mean, we were expecting, more than 200 people, but, most of the people are, involved in their Viva. We cannot force them to come. Thank you, sir. Thank you, sir. But still, okay. Okay. So we'll end the meeting, sir, then?
Sure.
And I must thank Dr. Antara Sarkar too. She's sitting at the back. And thank you, Antara, for facilitating this meeting. Okay. Okay. Thank you. Thank you.